Any other questions? Yes, sir.
Okay, are the courtrooms open?
Hang on.
Hold on.
Microphone.
Are the courtrooms open to the public where you can just sit there and
Yes.
kind of see? Okay, and what are the name of the courtrooms, like general sessions?
General sessions, there are 6 civil divisions. You can go down and sit in any one of them.
And
140
also,
Adams, and the bankruptcy court is on the hearing, well, there are 3 hearing rooms on the 6th floor of the bankruptcy. That is the main hearing room for 9 o'clock and 10 o'clock cases. You can go sit in one of the courtrooms and just listen. Sometimes it's going to be a little hard to hear because you're sitting farther back from where the lawyers and the judge is going on. A lot of this is worked out outside. A lot of this is before a trustee who says, why don't you need to do this? And they're announcing deals going forward. We may announce outside in bankruptcy, when you walk up onto the 6th floor, you get off the elevator, you go through a security screening area, and around the corner there are 3 individuals out of the trustee's office sitting at computers. Lawyers are standing in line waiting to announce and discuss their cases, what they're doing, whether they're going to continue them or whether they've been settled and so forth. And then behind them, sitting in chairs, are debtors who are told to be there by their client, by the attorneys, in case an issue comes up, so they can talk to them with the creditor's attorney. Usually, all of that gets resolved. These type of cases, in my experience, get resolved. It's only somebody that's trying to drag it out do you end up going to a 10 o'clock hearing. You usually get continued one time for a short 2-week period so the debtor's attorney, if his client's not there, he can talk to them and tell them what you got to be doing, and then they'll approve us signing their name, or they'll fax us an order with their name on it. We upload it in the bankruptcy system, the judge signs it, and we have it in about 3 to 5 days.
and with Section 8, is the social worker and that kind of stuff kind of does some of this for you when they get kicked out of the program and all that?
I'm sorry, that
With the
question,
Section 8 house, if they're Section 8,
They're
HUD,
Section 8,
whatever
yeah.
you want to call it, they're
Yeah.
there. Does the social worker and all that stuff kind of, if they get kicked out of the program, do they make the eviction for you and do that kind of stuff?
no,
No, you still got to do it.
no.
One second.
One other question?
One other question. I
Okay.
got 2 more, actually.
Okay.
Hello.
Hello.
I have 2 questions. I had an eviction last year, and we got the people out to have the judgments, the monetary judgment, but the lady has only income is Social Security. The gentleman was working at the time, but now he just works for money, which you can't trace.
Cash.
Cash,
Yeah.
that you can't trace. What other options do I have? Someone had mentioned that I could go and ask for a levy of some sort against property.
Yes, ma'am.
And I don't quite understand.
You have to have, you can do a levy, but you need to have hopefully a description of what you're wanting to be picked up. If the debtor hasn't filed an exemption notice in the court where your judgment is rendered, listing what property he or she claims is exempt from levy, then you can levy on personal property. You have to be careful. Car is a good levy, but it needs to be free and clear because you can't execute on equitable interest in personal property. If you can find of course, a bank account that doesn't involve Social Security or Social Security disability or something like that, you could levy on the bank account. Personal property, you're talking about going in and trying to get all their household goods. Then you're talking about a sale. Then you're talking about you have to post a bond to have that property stored. It's kind of a headache to do that. But I'm sorry, but you may be SOL.
The last,
I mean, there comes a point in time where it's better to cut your losses and move on.
Right, keep on. The other question is, and I was sharing this with Mr. Kirkland, Attorney Kirkland. I also evicted another person, and I had them served on their job. I know they're working, and I have, I forget the name of it, it's in my purse, where they have gone down to the courts and said we can only pay $40, and this is true, $40 a week, I'm sorry, $40 a month, which is going to take about 7 years for them to pay it off, okay? And I verified her salary, because that's the same salary she gave me at the time. When that happens, is it the court that looks at her papers and help her determine what they can pay and how often can they pay, or what do I have a remedy in that situation if I were to go to court and say I want her to pay me at least $40 a week so it won't take, 7 years to pay it off? What options do I have there?
Well, your options, no, the clerk's office does not help them determine what they're going to pay. The debtor has to come into court. They're going to file that petition to set payments, and they're going to put I've got this much in income and this is what I can afford to pay. They need to come into court with a list of what their monthly expenses are to give the court some decision. There are some judges that say, you need to show me that you can't afford to pay any greater than $40 a month. Because I don't know what the size of your judgment, you're entitled to interest on your judgment.
It was $2,800.
All right, so $2,800 at $40 a month, it's going to take you a little less than 3 years.
I'll be as old as Arnold.
Not counting interest on your judgment. So I mean, I understand your plight, but you need to, if they show up and all they got, you need to ask them to put proof on what their expenses are so you can determine whether their offer is a reasonable offer in light of their financial circumstances.
So if I agree to accept this, can I go back in at a later date and check to see if she's gotten a raise or gotten changes in her?
If at the time of the hearing you ask the court to set a review in 6 months, yes, you can do that, and I would suggest that you do that. Okay?
All right, thank you.
You're welcome.
One other question.
This is just more looking at if you're coming in from overseas, like we are.
I'm sorry.
We are from overseas. We're from New Zealand. If we buy properties here, well, you're a long way away from everything. But how often does this sort of process happen?
How often does it happen?
What's your advice? What's your advice?
Well, it really falls down as to who the tenant is that you've gotten. I don't know if you were here when Jim was talking about screening your tenants. You want to screen your tenants well. You want to make a determination that they do have the ability to pay you, and they're committed to this lease and can meet all the other terms and conditions. But it does happen. You need to understand, for bankruptcy purposes, 35–40% of the people in Shelby County file bankruptcy at one time or another, maybe more, greater than that. One time we were the capital for Chapter 13 wage earners. In other words, we had so many being filed. It was a huge number, but that includes refilings of individuals. So people go out, get back in, go back out, get back in. That is a potential problem. But that could happen to you. I'm not going to tell you it won't. But it really depends on your screening process and that you're able to get good tenants. You're not going to be perfect in that, but that's the best you can hope for.
Just one comment. When we had some issues in New Zealand with someone who'd taken our money and said he'd done X and he hadn't done it, and then we took him to court and we sent him stuff by Gmail, but he always claimed he didn't see it. So the people here who say they're sending stuff by Gmail, do they not then have to demand a reply? Because they're out in the court and they're making up all these lies, basically. But how do you... Yeah, but that's what we found anyway. That the Gmail allows them to say, oh, well, I didn't see that. Must have been gone somewhere.
Well, you're sending them notices of what? Non-payment of rent?
Oh, well, in this case, it was a contractor who had said he would do a job, but he took the money and didn't do it.
Okay.
And then we took him to try and get the money back, but he said he never heard what date it was going to be, and so he didn't turn up. That wasn't his fault, and on it went. And he had several email addresses. Well, he said, I didn't watch that one, he should have done that one. So there's always around, we found, if you do it by email. And in the end, we didn't get our money back, actually, but that was just an issue we found.
Well,
That's
yeah,
not
that's-
applicable to here, but I just think that's something to think about, maybe.
You entered into a contract with somebody to buy property? Do I understand that
Oh,
correct?
he was supposed to, no, he was supposed to file for subdivision.
Oh.
We were overseas, and he took the money, but he didn't do so. He said he sent us copies, but that was all false, so, yeah. So it was fraud, basically.
I don't know how much is involved.
It was about 3,000 New Zealand dollars to start applying for something.
Yeah, I understand. The question is whether you want to get engaged. I can tell you're not from here, correct?
Yes.
It's a little hard to communicate. I mean, to travel back and forth so quickly.
The question was not for you to resolve it. The comment was that Gmail turned out to be a problem because he could claim he didn't see them because he had several Gmail accounts. And I just wanted to make people aware that sometimes you need to serve people notice and they actually have to sign that they've got it, because that gets you into trouble later on.
Right.
That's really the point.
Okay. Thank you. Anyone else?
We got about 5 minutes, guys.
Hypothetical, you get your judgment of $1,000. You don't really want them to move. You don't really want another vacant house right now. So you make arrangements, and I understand the reservation of rights. But you know, then the next month rolls around, and now they owe you two. Let's say after 6 months, they've paid you $3,000, but they still owe you $2,000. My question is, at the point they pay that first $1,000 that the judge gave you, is it satisfied, or as each month accrues and they still owe you more than $1,000?
You got to start all over.
You have to start all over. At the point they pay you $1,000.
Once you accept that, basically you're entering into a new lease arrangement with them by asking them to basically stay.
I see. Thank you.
All right. It may be oral, but you're bound by that agreement.
How we doing, Bucky? Still have
Thank
a couple
you.
more slides?
Sir?
You still have a couple more slides?
No, that's it. We're done.
That's it. Just one point of clarity, guys. I mean, I know the real estate business can be traumatic, and it can be, somewhat emotionally taxing. Typical attorney charges about $150 to $200 an hour for advice. Bucky's fee for therapy is about 10 times that amount. All right? So we'll be collecting checks at the end.
Thanks, Jeremy.
Anyway, Bucky Phillips, everybody, give him a hand. Thank you very much.